Hello viewers, welcome to Ekam Academy. Today we'll discuss about Article 16 of Indian Constitution. In this series of concept of the day, we have discussed already 15 articles of Indian Constitution along with Article 32. So if you haven't watched the earlier videos, you can check in the playlist. All those videos are available for your conceptual clarity. Right. So first we'll discuss today about Article 16. So what does Article 16 talk about? So Article 16 is forming part of Article 14 to Article 18 of Indian Constitution, which promotes fundamental right to equality. So this is also part of one article which guarantees right to equality. In what aspects it is trying to promote equality, we'll understand in a while. But here, this right is only available to citizens of India. This is what we have to clearly understand. Right? Then we'll understand the provisions related to 16 from 16 clause 1 to 16 clause 6. Right. So we'll discuss about Article 16 clause 1. So what does this talk about? So it says that state has to provide equal opportunities in public employment for all its citizens, right? So in public employment, and this provision is only applicable for central government and state government related employments only. That is the provision of 16 clause 1. Then wait, what about 16 clause 2? 16 clause 2 says there should not be any discrimination by the state. No discrimination by the state. In what aspects it cannot discriminate? It cannot discriminate on the grounds of caste, race, religion, sex, place of birth. So generally these are also the grounds mentioned under Article 15. But along with these, there is also mention about residence and descent. So these are the additional grounds which were not covered as part of Article 15 but were covered as part of Article 16. So on these grounds, state cannot discriminate the citizens, right? Then what are the 16 clause 3 provisions talking about? So 16 clause 1 and 16 clause 2 talk about the general rule which is trying to promote equality. But to promote equality, sometimes we need to promote some affirmative actions in favor of weaker sections or who are vulnerable. So for those, we are trying to give them some exceptions to the general rule under Article 16 clause 3 to 16 clause 6. So let us understand 16 clause 3. 16 clause 3 talks about the power of Parliament to make a law regarding prescribing residence as the criteria in certain employments. So in some employments, residence can be mandatory criteria. So for those, in case if a law is required, who is authorized to make a law? It is Parliament of India according to 16 clause 3. So very important, what is that you have to remember. Then Article 16 clause 4. This talks about the provisions which can be made by the state in favor of any backward classes, right? Any backward class of citizen. Any backward class of citizens, right? So that means in case if there is a need, state can initiate or enact some provisions in favor of any backward classes of citizen. It is not backward caste, backward class of citizens, right? Then 16(4)(a) talks about reservations for SCs and STs. So if it is required, reservations for SC and STs can be mentioned in the employment opportunities. Then 16 clause 4b, it talks about reservations in promotions. Reservations in promotions in favor of SCs and STs. Reservations in promotions for SCs and STs. So this is also guaranteed under Article 16 clause 4b. So first here if you see, this was inserted by 77th Constitutional Amendment. Right? This was inserted by 81st Constitutional Amendment, 16 clause 4b. Then what is 16 clause 5? So this 16 clause 5 specially talks about religious denominations. So for example, if we take the case of TTD, denomination, okay? So TTD is a religious denomination which has some set of rights under Article 26 of Indian Constitution. So to appoint a person to TTD, he also need to have some religious affiliation which is matching with that particular religious denomination. So religiously qualified persons only can be appointed to such religious denominations, that is there under Article 16 clause 5. Right? Then what is Article 16 clause 6? So this was inserted by 103rd Constitutional Amendment passed in the year 2019. As we very well know, this is providing reservations for the persons who are belonging to economically weaker sections, and 10% reservation is being given in central and state government related employments for those who belong to economically weaker sections in the open category, right? So this is what under Article 16 clause 6. Now let us look into the state cases of related to Article 16. So first one is Madras versus State of Madras versus Champai Daru Rajan case. In this particular case, what actually happened is educational institutions and the reservation concept, right? So educational institutions and reservations, that is the main conflict of this particular case. So in this particular case, Supreme Court has said, so giving reservations is not a violation of equality. So they have upheld the reservation concept and said reservations are not a violation of equality and the related provisions. Then important case related to Article 16 is Indira Sahni versus Union of India case, a very important landmark case where Supreme Court has said reservations are being upheld, right? So reservations are actually upheld, but these reservations cannot cross 50% limit. So they have imposed some glass ceiling, right? So this cannot increase more than 50%. That means whatever the reservations you give to the SC, STs and backward classes and everyone, that has to confine within this 50% limit. That is what major outcome of Indira Sahni versus Union of India case of 1992. Then in Nagaraj versus State of Union of India case, so whatever the amendments that were made to include SC, ST reservations in promotions, so that was actually upheld by Supreme Court in this particular case. So whatever the provisions that were included to ensure that reservations in promotions will be actually given to SC and STs, that was upheld by this particular case. But they said when you are going for reservations and promotions, some criteria have to be ensured. So it should involve some elements of efficiency, backwardness, and in case if there is no proper representation, then only you can go for reservations and promotions. So some set of guidelines were mentioned, but they said those were being upheld. But later in this particular case, Jarnail Singh versus Union of India case, you can say, or Lakshmi Narayan case of 2018 case, in this particular case, Supreme Court said state actually need not collect. So state need not collect quantifiable data to justify reservations in promotions. So need not actually. That is what the main observation of the Supreme Court in Jarnail Singh case. Now let us see the practice question related to Article 16. Under Article 16 clause 4, state is allowed to make provisions for reservation of the post in favor of which particular category. So if you know, let me know in the comment section. Then today, as part of the concept of the day, we have discussed about Article 16 of Indian Constitution, 16 clause 1 to 16 clause 6, along with the important cases related to Article 16 in a nutshell. So if you like the video and found informative, let me know in the comment section. Thanks for joining. All the very best.